first session, the key word for me today is context when it comes to conducting coverage of this decision and exploring some of the jurisdictional impacts from the reaffirmation of the Muscogee Creek Nation Reservation. Once again, we are joined by some of the best tribal law professionals towards this end. Muscogee Creek citizen Sarah Deer, distinguished professor at the University of Kansas, and Lindsay Robertson, University of Oklahoma professor of law and Chickasaw Nation Endowed chair in Native American law. Also joining me today from the first session are my friends at Muscogee Media, who have helped us coordinate and conduct these events. This includes Jared Moore, who is handling production, as well as our moderator today, my good friend, Angel Ellis. Just a note that audience questions may be submitted using the Q&A feature. From there, Angel, I'll hand it over to you.
Thanks, Sterling. I just want to say thank you guys for taking time out of your busy schedule to be here with us and discuss such an important topic in Indian country right now. And it's an important news topic that we're seeing play out all over different publications and in the 5 o'clock news. And we are always looking for a better understanding of what it means to be covering the McGirt case, the different things we see play out and after the McGirt opinion has been issued, and all the relative topics that we'll see going forward as we basically see us kind of rewriting a system in history. So one of the big foundations of journalism requires that we seek truth and report it. According to SPJ's Code of Ethics, a major component of truth is context. And at this point, I would love for each of you to kind of, we'll let Sarah, ladies, go first, but can you give us some of the historical context that's really important to any journalist who's going to be, boots on the ground and trying to cover a topic in justice and McGirt?
Thank you. Thank you for inviting me, first of all. I'm really thrilled to be here. And while I am a Creek citizen, I do not speak on behalf of Creek Nation. I am one of the advisories on the Protection Commission, but I'm speaking today in my personal and academic capacity. So just get that out of the way. So thank you very much for raising these important questions. And I would agree that I think some of the coverage I've seen in Oklahoma has been quite one-sided in a lot of ways. And so in order to really understand what the McGirt decision is, you have to dig into the history a little bit and understand sort of how we got to Indian territory, but also the kinds of treaties that we signed with the United States. And in some ways, McGirt is an easy case. It has, I think, created a lot of complications for folks, but it's a fairly simple, straightforward case, right? You have a treaty. The treaty says forever. Congress has not said otherwise. Therefore, the Creek Nation Reservation still exists. So it's just reading the treaty. It doesn't require any particular skill set or training to read a treaty, especially when the language is very clear and plain. So that peace treaty we signed in 1866 was a peace treaty with the United States. It did require the sale of some of our land that we had up to that point, but then it created this reservation. I mean, it was a smaller reservation, but it was based in in the efforts to address some of the challenges after the Civil War. But it does use the word forever. And that's what Justice Gorsuch, in the case, he authored the opinion. That is why it is a fairly straightforward question, especially for a textualist. Now, I think a lot of people were surprised to see a more conservative justice side on behalf of tribal nations. Sometimes people associate liberal justices with being more tribal friendly and others with not, but it doesn't always fall in line with the liberal conservative polarities for other social justice issues. So for example, Ruth Bader Ginsburg, who has a female attorney I, of course, admire, was not always on the side of tribal nations, especially early on in her tenure. So it's a conservative justice that made this decision consistent with a conservative reading of the law. And it really does need to be put into that context. It's a fairly straightforward case, and it's based on a treaty that anyone can read and come up with the same conclusion that the court did.
Mr. Robertson, you have anything to add to kind of the historical context of, you know, what got the tribes to this point and where we're at, you know, in this point in history in regard to, you know, the reaffirmation of jurisdictional, you know, of the reservations?
Yeah, no, it's an enormous question, and I think Sarah's answer was dead on. Yeah, I guess the only thing that one could add would be for journalists to sort of be aware of the fact that the Muscogee Creek Nation didn't just pack up and move out here because they thought it would be a fun thing to do. There's a whole sort of Trail of Tears experience, the 1830s and 40s, forced removal, hardship, and that's sort of the backstory. And then the promise that we're going to leave you alone when you get here makes the violation of the promise even more horrible when you think about it. And then the fact that the act that allegedly disestablished Muscogee Creek Nation's 1866 reservation was late 19th, early 20th century allotment, which was a process that President Theodore Roosevelt described as pulverizing the tribal mass. So this is sort of insult to injury to insult to injury. The breaking up of collectively held tribal lands essentially by force, allocation to individuals. Muscogee Creek Nation did the best they could to keep the whole thing intact, only then to have the state with federal acquiescence sort of run all over them jurisdictionally for decades after that. So those are sort of the bookends, I guess, of the experience that Sarah was describing.
I kind of, I always veer off course a little bit, and I think that you guys are probably really well equipped to answer this, but when you talk about the state and how it's, you know, interacted with the tribes, when we're looking at the justice system as it sat last year, I think what's really missed in a lot of reporting is that there was a system of Indian justice before there was a state of Oklahoma. And can you kind of just give us some insights into understanding that process and why the state of Oklahoma ever prosecuted the people who were raising these appeals to begin with?
Will Professor take care of that one?
I'm happy, yeah.
I'll pitch it to you, Mr. Robertson.
No,
you have your choice of professors.
Yeah. Go for it, Lindsay.
Okay, so yeah, well, there are sort of multiple levels, Angel, to your question. Did Muscogee Creek Nation have a dispute resolution system before Europeans arrived? Yeah, as any political community does. Did they have a dispute resolution system, including a criminal justice system after Europeans arrived? Yeah. Did they have one that came with them out west when the Trail of Tears migrations took place? Sure, of course. And they would have continued, one assumes, to enforce Muscogee Creek criminal laws right up to the present day had there not been federal and state interference with that. The rules, the criminal jurisdiction rules overall, some trace to federal statutory law, where the federal government has sort of claimed criminal jurisdiction over offenses that occur in Indian country, principally through two statutes, the Indian Country Crimes Act, in which the federal government said, you know, ostensibly to help keep the peace, if any tribal citizens commit any crimes against non-Indians or vice versa in your Indian country, we'll take it, we'll take care of it. You guys can also prosecute the tribal defendants if you want, but otherwise we'll take it. And if any tribal members commit major crimes, this is the Major Crimes Act, against anybody, we'll take all of those because you know, we think that's the best thing to do. These statutes, by the way, explicitly the major crimes that were passed, questions were raised: how can the federal government do this constitutionally? And the answer the Supreme Court gave in a case from the 1880s called U.S. versus Kagama was, well, the federal government is the guardian for the tribes, and this is, you know, at least arguably in the tribe's best interests. So yeah, so the federal government does have the power to claim criminal jurisdiction over these offenses. And that only leaves one category of offenses unclaimed, and that's non-Indian versus non-Indian crimes that takes place in Muscogee Creek Nation or any other tribe's Indian country. And the Supreme Court took care of those in a line of cases that began with a case called U.S. versus McGratney, so we call it the McGratney line. And the Supreme Court said in those cases, well, you know, tribes don't really have any particular interest in non-Indian versus non-Indian crimes, and neither do the feds. So let's let the state take those. And so it's really the tribe having its own system of criminal law enforcement, parts of it being taken away by the federal government and parts of it being taken away by the Supreme Court. And that's been the sort of awkward universe that all tribes have been forced to live in as a result of these federal actions. And that, by the way, it still applies to Muscogee Creek Nation, the sort of three sovereigns playing a role. It's just post-McGirt over a much broader area of land.
I love to just introduce the topic just for the benefit of common knowledge and media journalists. And I think that Professor Robertson, I've heard you describe this in other forums, and I think you do a really wonderful job of describing it, but that's sovereignty. And can you just kind of give us this scope of the relationship between a sovereign tribal nation, the state of Oklahoma, and the federal government? It's kind of the most, I think, misunderstood concept in media.
Sure, yeah. So sovereignty is a word that gets thrown around a lot, and it lives in multiple universes at the same time. So you hear, literary critics will talk about sovereignty, including, friends of mine who write about Native literature. It's a political term, sovereign. And so, but I live in sort of the narrow world of a lawyer / legal historian. And so I tend to think about it. And I was actually just talking to my Indian law class about this before we started. So sovereignty, I think, maybe most usefully understood from the perspective of where does the power to do something come from? So sovereigns, when we think about sovereigns, we think about governments. We think about sovereign, the word originally is like a head of state in a monarchy is the sovereign. But the sovereign power in a republic or a state that's not a monarchy maybe resides in the people. But we're talking about political entities who claim the power to do stuff. And so sovereignty itself, I think, maybe deals less with the question, what do these governments get to do, which is sort of the scope of power question, than it does with the question, where does their power to do stuff come from? And there are only two places it can come from. It can come from outside them. I'm a city government in Oklahoma, and I get to do stuff. But the only reason I get to do stuff is that the state government has given me the power to do that stuff. Well, I'm not a sovereign because I'm not exercising power independently that generated from me. I was delegated the power to do it. So the state may be a sovereign, but I'm not. On the other hand, if the power to do something actually does emanate internally from me, as a matter of history and as a matter of sort of political understanding, then I am capable of delegating power to others, and I'm generating power myself. There may be externally imposed limitations on the exercise of that power, but it's all coming from within me. This is how all of the recognized nations of the world operate. France does stuff as a government because it internally generates the power to do stuff. England does the same. The United States does the same. Russia does the same. Argentina does the same. And so do all 570 plus tribal nations that are recognized by the federal government, arguably even those that aren't recognized by the federal government. But we'll stick, since we're talking about Muscogee Creek Nation, with federally recognized tribes. They have been recognized by the Supreme Court of the United States, specifically in an 1896 decision called Talton versus Mays, as exercising inherent power. Now, that means that they are sovereign. The source of their power makes them sovereign in a global sense. And they're two consequences to that I want to share because I think they're important. One of them may be important more academically or to certain criminal defendants than others, but that's, as people probably know, there's something in the Constitution called the Double Jeopardy Clause. And this is an international law rule too, that says you can't be prosecuted twice for the same offense. Well, because tribes are sovereign, because they exercise inherent power, they aren't subject to the Double Jeopardy Clause when they prosecute somebody who's subsequently prosecuted by another sovereign, most commonly the United States. So the fact that their power is internally generated, that they are sovereigns, means that they in the United States can cooperatively act as sort of partners in prosecuting somebody effectively twice for the same offense. And this happens fairly routinely. All right, that's the less interesting one, the one that's more troublesome maybe for criminal defendants. The more interesting one, and it's surprising how many people don't realize this, is that tribes, same decision that established the inherent power rule, Talton versus Mays, tribes the question arose in Talton versus Mays, which was a Cherokee prosecution of a criminal defendant. Are tribes subject to effectively the Bill of Rights of the US Constitution? And the answer that the court came up with was no. Now, first of all, what is the Bill of Rights? A lot of people, I think, don't understand it. The Bill of Rights is basically a list of rights that we as individuals have that we can enforce against some government, clearly against the federal government. Virtually all of them nowadays we can also enforce against the state governments through a doctrine called incorporation through the 14th Amendment Due Process Clause. But what the court said in Talton versus Mays is we can't enforce those rights, those Bill of Rights rights, against tribal governments. And the reason is that tribes are sovereign, exercising inherent power, and they were not at the Constitutional Convention in Philadelphia, and they didn't sign the federal Constitution. That's basically an agreement among the states and effectively the United States, which is the political entity, the new sovereign created by the Constitution. Now, a lot of people freak out when they hear that tribes aren't subject to the Constitution. I've gotten into fights with people who ought to know this, who don't, law professors who are incredulous that tribes aren't subject to the Constitution, but they're not. Tribes are subject to a federal statute called the Indian Civil Rights Act, which was passed in 1968, and as a federal statute passed by the US Congress as guardian for the tribes, imposes some of the provisions of the Bill of Rights on tribal governments, including equal protection and due process, doesn't apply a bunch of them, including the Establishment Clause. So tribes can have established religions if they want to. Pueblos can have a cemetery just for Roman Catholics that's supported at public expense. That's because they're not covered by the Establishment Clause, and there's no Establishment Clause provision in the Indian Civil Rights Act. But the act itself, it turns out, and this is another Supreme Court decision, Santa Clara Pueblo, contains no what's called a private right of action provision, which means that while tribal governments are subject to these Bill of Rights like limitations as sovereigns exercising inherent power, those statutory rights can't be enforced by me if I think a tribe has violated my rights in a federal court, nor can they be enforced in a state court. They can only be enforced by me in a tribal court. So the tribes have control ultimately over the scope of rights that they're going to provide to persons who appear before them as a governmental entity. And it'll be those Indian Civil Rights Act provisions, or, and this is more common, Bill of Rights provisions included in tribal constitutions, or statutory rights included in tribal statutory codes. And those are things that sovereigns get to do. They define the rights that they will respect. They engage in multiple prosecutions, right, with other sovereigns who are operating as colleagues. And they aren't subject to limitations imposed on other governments by their own constitutions.
So I want to take this opportunity to, I'm going to dive further down the rabbit hole and ask Sarah, can you talk a little bit from your perspective as someone who's advocated for victims, when we're talking about, the tribe's inherent sovereignty to enforce their punishments on collaboration maybe with the federal government and double jeopardy. We saw the narrative playing out that, oh my God, crooks will be running free and people will not go to jail, and it's very scary. But can you tell us what it actually means for, the potential to administer justice to Native American, victims of crimes, and what that looks like? Because I feel like maybe we're seeing something even more solid coming out.
Yeah, I think so. It's fascinating because both Murphy, which was the tie case, the 4-4 decision, and then the McGirt decision in 2019 or 2020 rather, were predicated on pretty violent people, right? So Murphy had committed a pretty heinous homicide. All homicides are heinous, but there are grisly facts involved. And then Mr. McGirt, raped children. So how does that become a tribal sovereignty issue, right? And so certainly a lot of tribes intervened in the case because we had a vested stake in the outcome. Because if our reservation still exists and McGirt and Murphy are tried by the wrong government, the default then is that our reservation is preserved, right? So it was a little bit awkward. And so I filed a couple of briefs. I filed a brief in both cases with Cherokee attorney Mary Catherine Nagel, who's a counsel of record out of Pipestem Law. And we filed amicus briefs on behalf of Native victims of crime to try to persuade the court to understand that sovereignty is necessary for safety of Native women. So we weren't necessarily siding with the defendants, but we were thinking about victims when we wrote the case. In fact, one of the things that's really hard for a lot of Native victims right now, especially in Oklahoma, is to hear about a McGirt victory, because McGirt is the last name of a man that did pretty serious harm to people. So the way I see this, right now, Native people are the most victimized population in the United States, and are also very over incarcerated, right? Both of those things can be true at the same time. And the fact of the matter is, whatever we've been trying to make work in terms of addressing victimization and addressing over incarceration, are now, there's more muscle right now to address those things, right? Because the territory by which the territorial reach that the re-recognized reservation has means that Creek Nation, with a few exceptions, can handle crime on the reservation. And it hasn't necessarily been the priority of federal or state governments. I've talked to hundreds of victims whose cases got thrown out of federal court and were declined by the U.S. attorneys, or never got justice from the state court system. And that's what's led to this crisis of over victimization and over incarceration. And so this is an opportunity for Creek Nation and other tribes that are affected by this to say, we're not going to tolerate violence in our community. And now we have the territorial reach that we can protect even more people under tribal law. So while the case often is characterized as, defendants getting out of jail and defendants being able to get the case dropped, it's missing the story of Creek Nation having wider territorial reach to protect its own people. Because who has the most incentive to protect the people is the nation, right? So I think it's a little odd that we sided with these defendants, but their arguments and their the task of their attorneys to try to get their clients off of death row and out of a 1,000-year prison sentence. I mean, you have to give a lot of credit to them, but it is at the end, an opportunity for Creek Nation to be able to exercise its power again that has been denied to us for so long.
So I know that this decision, as it came down from the Supreme Court, and even following or the opinion as it came from the Supreme Court, and even the follow-up and how we implement that is being really widely watched across the nation right now. And when you think in terms of safety of women, in the victimization of Indigenous people, and the prosecution of Indigenous people, why can you kind of give us that broad scope understanding of why tribes across the nation are looking into that? We have crises of missing and murdered Indigenous women everywhere. It's spanning other countries. It goes on to First Nations in Canada, and it's south of the border and Indigenous populations. So why, this particular instance, this little snapshot of our history, is it important that we really preserve and report on it properly because everyone's watching? Can you kind of talk about that a bit?
Yeah, so there's been some coverage about victims whose cases have been dropped, and I think some fear mongering it underlies some of that, but Native women suffer the highest rates of violence in the nation, and the relying on their state or federal government to solve that problem for us is not working, and you also have to think about the victims that came forward, especially the McGirt victims. This would have never happened if the victims hadn't come forward in those cases. But when victims are reading in the paper, hearing on the news that dangerous criminals are escaping and that there's no accountability for them, that says to other victims in the communities, they read that and they think, well, I'm not going to come forward with this. I'm not going to report this crime because I understand that the perpetrator may walk free, right? So I think that's something we have to think about, is the impact on the reader, who is a vulnerable person and is scared and trying to figure out whether to come forward. And then they're reading in the newspaper that, the McGirt is releasing all these folks. So I guess that's my answer there.
In an earlier panel, they kind of addressed that particular news story as more of a problem of implementation and communication rather than a problem of a U.S. Supreme Court opinion, because there was many factors not considered when they were talking about the release of this rapist, and that one of them was that the federal statutes have run out, and that has nothing to do whatsoever with Indian country at all. So like when we're processing this information in our community, and some of us are Indigenous citizens, that the comments that come from those kind of stories are just wildly incendiary, and as they should be. People don't want to see people harmed, but being a member of a tribe and then having this thing associated with tribal citizens, and then here's a horrible scenario again, has been one of the most harmful kind of handling that I could really point out. But of all the ethics of journalism, and this is one of them that really kind of sticks out, is minimizing harm in our reporting. And can you kind of point out any more or any broader harmful impacts that could occur if we're not providing, fair and equal coverage? What kind of damage is done when we leave tribes out of these conversations, when we fail to protect the victims, or we ignore a tribal citizen's perspective?
Yeah, I think that's really important. The Family Violence Prevention Program at the Muscogee Creek Nation is an outstanding nationally recognized victim service agency. It's known, not just in Oklahoma, but across the United States, that the Muscogee Nation Family Violence Prevention Program provides excellent services and advocacy to victims. And they don't just provide those services to Native people. Anyone that needs their support, needs their help, can benefit from their services, Native or non-Native, is able to get support, advocacy, court accompaniment, help filling out forms, right, for anyone who is a victim of crime in that reservation. And that part often we don't hear about. We hear about somebody being released, but then we're not also hearing about the tremendous efforts that our tribe's victim advocates play in this work, and they will stand with victims. So I think that's an important kind of counterpoint to the trope about, tribes being power hungry or being somehow interested in setting people free. it's frustrating. And the other thing I think that we have to be real honest with ourselves about is that there's a little bit of a racist tinge to some of this. I mean, the whole point is that tribes are political entities, right? But when we start looking at, say, comments on a news article, and we see people saying things about tribal nations as being barbaric or savage, or they just need to assimilate or whatever, there's almost a fear of tribal nations, right? That may be based in what people saw in Westerns growing up, that Native people are brutal to each other and that we stake people to anthills and that's how we solve all problems. And I think if more journalists were to come into tribal court and learn about tribal court and learn about our laws, that might go a long way in terms of balancing the coverage.
And that's a great point to kind of like, point out, is that there are tribal courts. I attend them frequently, or I did before COVID, but I rarely see reporters representing non-Indigenous news organizations in those. And I think this is a great time to queue up Professor Robertson to talk a little bit about these tribal court structures and how, going forward, we might face challenges, but is it really as scary as it sounds in some of the articles that we've read?
Yeah, no. It really isn't that scary. I think that tribal court proceedings, for people who want to sit in on them, I'm a Supreme Court justice on the Supreme Court of the Cheyenne and Arapaho tribes and have been for a while. And I think our hearings are every bit as uninteresting and boring as state court hearings or federal court hearings are. No offense to my federal and state court judge colleagues. I'm betting that Sarah's experience is very similar. They're, sometimes exciting, sometimes, but usually really mundane. And, the thing that I think folks who don't have experience in working in Indian country could probably very profitably reflect on is the fact that this isn't the Wild West. These are governments with responsibilities, with organized departments who are providing services for communities about which they care. They have all the strengths and weaknesses and problems of any other human organization. But the goals are basically the same: quality of life, safety, education of children, healthcare for people, especially these days, looking after older people, protecting children. All of these are very common, and it may be that different communities resolve the questions differently as to how best to look after these particular interests. But there really isn't a whole lot to be scared of. The anthill thing that Sarah mentioned, but that hasn't happened in 15, 20 years or so. Any place we don't do it at Cheyenne Arapaho anyway.
As we're journalists navigating, covering like a justice beat, for instance, we often request documentation. And can you kind of give us some pro tips on how to do that with tribal courts? I go into them every day. I ask for a case number and get it printed out, just like I would at any other court clerk. Do you think that that's something that like maybe is lost on, like that ability actually exists? You can do that, for any reporters out there trying to cover, these in the future.
Yeah, I mean, almost every tribal court in the nation is a court of record. It's a public event, right? And so I think sometimes there's a little nervousness about approaching a court system that you're not familiar with, but the vast majority of them are going to look and sound a lot like what you see in any court, and the only exception really would be around customary law, things that the tribe does, kind of common law, I guess, is how it would be described, right? How did we govern ourselves? And what that allows the court to do is to tap into some of those values, right? That we aren't going to tolerate, raping children on our reservation. So yes, I think that getting those introductions to the different tribal courts would be a really great way to start, diving more deeply into what's happening with Creek Nation and other tribes. And I also think that, when we when we talk about sovereignty, we take it for granted in every other context, whether it's we don't even, like, I'm in Kansas right now. I never think of Kansas as being a sovereign, right? Even though it is, right? And so I think what Professor Robertson said earlier is really, really important. And that is that sovereignty is inherent, right? It's not something that the government gave us. They didn't give us a reservation. They didn't give us these things. These things are inherent. That the Creek Nation was indeed operating a constitutional Supreme Court throughout most of the latter part of the 19th century. This isn't new. We've had courts, so we have a Supreme Court, we've had other courts over the years. And so this is not the first time, right, that we're trying to confront this. It's not something we just decided to do in 2020, right? It's got a long history, and researching the history of tribal courts can be really valuable for journalists. There's a number of great books out there about how tribal courts function. So the information is there. Sometimes just people don't know even to ask for it.
Yeah, and it is one of the challenges when you're covering such a huge topic. I kind of relate this out like, you have a deadline and that's never going to change. But this story in particular, you're going to have to go through 5 or 6 layers before you have more comprehensively covered it. You have to address these federal, aspects and avenues, and the state aspects and avenues, the tribal, the scale of it. And then you also have to address the fact that you have stakeholders involved. I wanted to I'm trying to reach out and get Professor Robertson to really describe. I heard you talk about sovereignty once on a panel with APTN, and Sarah touched on how people think that it's given to you, but you kind of touched on how the evidence of that is really unique to the United States and how the United States views tribes. Because when we had these treaties in the first place, these were sovereigns coming together and making a deal. Can you kind of talk about that for a little bit? Because I think that's real important to understanding the scope of this report.
Yeah, treaties, it's a question about how Europeans colonized the rest of the world. And, for instance, Latin American colonization was not commercially driven and negotiated treaty based. It was crossbows and swords, right? And it was violent, and it was basically conquest for the church. That was the legal theory that rationalized it. English colonization of what became the United States was very different. It's post-Protestant Reformation, so the Pope had nothing to do with it. It was Henry VIII and his divorces. And so the English did it not to spread the Church of Rome, but really to make money and establish some naval bases to take Spanish gold as it was sailing back to Madrid. And so what that meant was, it was also later in time, and so when the colonists arrived, they didn't have the military advantage over the native people they found on the eastern coast of the United States that the Spanish did over a lot of the communities they met in Latin America a century and a half earlier. So what these largely commercial immigrants decided to do is to do what they always did when they were trying to navigate their way in a new area, which is cut deals with people. And it took the form of treaties because they're dealing with sovereigns. And so treaty making starts almost immediately in the Virginia colony, and it's continued in the New England colonies. There are thousands of treaties from the colonial era. There are thousands of treaties from the post-colonial era, most of which were ratified, some of which weren't, large scale and small scale. But treaty making, which is to say contracting ultimately between sovereigns, because the state would take on the responsibility from the colonizer side with the tribal government, that was the goal anyway, became the hallmark of relations between colonizers and native people in what became the United States. I think that we make a mistake when we assume that, and maybe this was the point you were coming after, Angel, was that that's the way it was everywhere else too. The reality is it was that way nowhere else. There's one treaty in Aotearoa, New Zealand. There is one aborted treaty in Australia negotiated by a private citizen with the happy name of Batman, right? The Batman Treaty, which was never ratified, but they still talk about it because it was the closest thing they've ever had to a treaty. And then there are a handful of treaties in Canada, but a lot of those were negotiated in the 20th century. And they're sort of modern deals with recognized First Nations governments to set boundaries and natural resources rights and things like that. And that's kind of it. And so we actually, you know, I do a lot of work in Latin America. They would love to have treaties. I mean, we talk about treaties being broken and unfair and stuff, and all that's correct. But we've got treaties, and they actually contain rights that can still be enforced in domestic courts. And that's something most Native peoples in the world dream of having and simply don't.
Yeah, and it's kind of one of those things that I've kind of reflected on as a journalist in this era where we're writing news stories every day, and to come from a place of here we were, a sovereign people negotiating with another, you know, group of people. How did we get, like, we got to this place where people forgot that we were that sovereign within ourselves, and all of a sudden our court systems were taken over by other folks. And so I feel like it's a huge responsibility for journalists to get it right, get the historical context right, because every day we're documenting history being made for the benefit of future generations. So I think this is a good time that we switch some gears and talk about a little bit of like the actual laws that are coming out right now. And I'll try to keep it as simple as possible so that you don't have to speak for a Reservation Protection Commission. But right now, the Muscogee Creek Nation is adopting policy and law that helps to close gaps. You know, so we have our own laws and constitution, and then the state of Oklahoma has its thing going on. So there's this almost kind of gray area that we were floating around for a few months. Can you talk about that a little bit, Sarah?
Sure. Well, one of the examples that I know folks have covered pretty extensively is the marijuana question, right? Until very recently, it was a felony to possess any amount of marijuana under Muscogee law. So what that meant practically is that even if a Native person had permission from the state of Oklahoma to possess marijuana, would potentially be in legal jeopardy for Creek Nation. And so once that was realized, and once people understood what was at stake, that it was one of those little gaps we had to fill. And so now the council has passed a law that allows Native people on the reservation who have the documentation and permission from the state of Oklahoma to not be prosecuted by the tribe. So it's just an effort to make sure that there wasn't a double standard on the reservation. So those are the kinds of laws that we're looking at right now. The other thing is that we have a much wider swath of land that we have to patrol, or that our light horse police has to patrol. They're also cross-deputized with many non-Native police departments throughout the reservation. So one of the challenges was also that our traffic code was not as strong as our as the rest of our laws, and so we want to help law enforcement officers understand exactly what they're doing. So our traffic code now is very consistent with the Oklahoma traffic code, so that there's not a question when you pull someone over, right, as to what you're going to do. So that's the kind of thing the council's moved quickly on. There may be other examples of that. Where we want to shore up our laws, but we have a pretty cohesive criminal code. Creek Nation does. It includes homicide, it includes rape. Basically any type of crime that a state could prosecute is also a crime on our books too.
And I just would love to pick your brain, Professor Robertson, and see. So the McGirt opinion comes down in July. Here we have a sovereign government that has ratified 92 pages of traffic code and an updated narcotics code within like 90 days or so. Like, what's that like? I mean, what other governments do that? Can you kind of give us your opinion on that?
It's efficient. You got to give them credit. Now, mind, this was something that must have been, well, I'm sure it was in the back of people's minds since Murphy. So there had been a little bit of time to think about this and start planning for it before McGirt came down.
Yeah, and I don't think I've ever seen the state move that quickly on anything. So when I hear the news stories about all the horror that could happen, I'm actually kind of glad to see this niche government being able to effectively and quickly address the problems. And within 30 days, I think we saw them dump in about $2 million into policing. And so that was something pretty significant that didn't get a lot of reporting, as this has been playing out. So I wanted to kind of ask if there are any instances or scenarios in either of your opinion that could be advantages to justice for Indigenous citizens because of this.
Mm-hmm. Well, for me, it's the volume. We can do more now than we could before because the territorial reach is so much broader than what had been recognized in the past. And so that allows us to provide services and protection for more of our citizens. And, to the extent that we have this over-incarceration problem where more Native people are in prison than they're a proportion in the population, there are things that we can do for our citizens and for Native people in tribal court that are not punitive if they're an addict, right? And this is part of the conversation around policing and the incarceration system in general, is that we have a lot of nonviolent people in for drug charges, right? And what some tribes have done is develop their own system of drug courts, which is not a punitive court, it's a therapeutic court, right? And instead of being put in jail, you're put on a plan for sobriety. And you check in periodically with the judge and the probation officer. And if you can keep up with their plan, then the charges will be dropped at the end of that. I mean, that makes much more sense to me than, throwing people into jail because of, a disability, an addiction. And so Creek Nation has the opportunity to create these kinds of more productive or more stronger ways to deal with some of the problems that we have. And now we can do it for even more of our citizens if they're caught up in an addiction issue on reservation or not. So it's really an opportunity to think about creative solutions that we have now, that we have at our purview. And there's a lot of very wise lawmakers in our council that are thinking very, very hard about some of these issues.
Can I add something to that?
Absolutely.
Just because, Sarah mentioned earlier that sort of Indian policy isn't really a conservative or liberal thing. It crosses lines. And I think this is a good example of that. It's, if you're a fan, and this is sort of a traditional, at least in the modern era, Republican/conservative view that of local government, like closer to the people is better than a distant government. What's happened is that the responsibility for defining what conduct is acceptable, what conduct isn't acceptable, and what the sanctions for committing unacceptable conduct should be, which is to say criminal law, has been transferred for Muscogee Creek citizens over a much wider area from the state of Oklahoma, which is a relatively large entity with some participants who might understand Creek culture, some who don't, some who are from radically different backgrounds, directly to the community that's most directly affected by the definition of the standards, the determination of what the consequences for violating them should be. So we've got the new world is a criminal law regime that's far more understanding of the individual life circumstances who are affected by the criminal law system. And if you're, as I say, a conservative believer in local responsive government, understanding local issues better, then this should be a good thing for you.
We have a question from our chat. Matthew Carter is asking for each of you, as experts in Native American law, what weaknesses do you see in media coverage of both tribal sovereignty issues and the McGirt decision?
I think the biggest one, again, coming from, a victim perspective, victim advocacy perspective, I think the continued sort of, cases are being dismissed, and so victims are being left in the lurch, I think is problematic. I'd rather see more coverage about the successes of the tribal nations in addressing some of these problems. And so, for example, with the LeRoy Smith case that made coverage, that was about a serial rapist in Muscogee, and he was released from both state court and then kicked out of federal court. And it was sort of blamed on McGirt, right? Oh, well, because of the decision, the state couldn't take action. And then the federal government tried to, but the statute of limitations had run out, and sort of framing that as somehow, our fault as Creek Nation, when in fact, the state of Oklahoma sat on that rape kit for over 15 years without processing it, right? That didn't get in a lot of the coverage.
I don't think it got in any of the coverage.
Yeah, and so the worry, again, I know I mentioned this before, but what message does that kind of coverage say to a victim tonight? She's been reading the papers and watching the news, and it looks like, it's a disaster. And so if I'm trying to make the difficult decision of leaving an abusive relationship or reporting the rape, right, there may be an instinct among victims who read these stories that, there's no point anymore. So I think that's been my biggest concern, because again, I'm always looking at the sort of victim story. So that's my take on it. I'm sure Professor Robertson can think of other media challenges that we're looking at.
Well, yeah, no, I think that's all right, and that may be the most important. I think other things that you see, they're sort of spin-offs the state's argument before the Supreme Court, which was a parade of horribles argument that the lawlessness and zombie-like released prisoners walking the streets of Tulsa and this sort of thing, and it really hasn't happened. And so I think, but it's not just on the criminal side. So the other story that was told a little bit, Tulsa paper covered this, I didn't see it, Norman, was that Mr. McGirt was re-prosecuted by the feds and found guilty last week, and we're awaiting sentencing. So that was one that just got moved from one prosecuting sovereign to another, which is really all that's supposed to happen with this reshuffling of jurisdiction as a consequence of the re-recognition of the reservation. The other side, where I think there's been a lot of misinformation flowing, has to do with civil regulatory power. And you see this, and I think this has generated, this is understandable, anxiety about, well, who do I pay taxes to? And a lot of it's, I think, coming out of the energy sector, the oil and gas industry in particular. We don't want this tribe, who knows, this Indian stuff, and they're going to be taxing our regulating oil production and this sort of thing. And I think that just largely came from, frankly, a lack of sophisticated understanding of how the rules of civil regulatory jurisdiction work in Indian country, and overestimation of what the tribe could do in certain instances, would do in any instances, because of a lack of understanding of the political realities at Muscogee Creek Nation and the nation's interest in, sort of shared interest in employment and all sorts of other things. So maybe, from the question was about journalists, but maybe making a deep dive into the rules that matter, to explain them to people, to sort of ameliorate anxiety a bit on both the criminal and the civil regulatory side would be helpful.
It's been tricky for us to ever get anyone on the record for the civil side. I think that people feel more comfortable talking about the criminal side because it's more defined in that opinion than anything else. And I think that, but this leads me into a really probably relevant question for each of you. As we're going forward, what are some topics that we haven't seen in the news lately that either of you think should be looked into? And I think that Professor Robertson kind of just, touched on that a little bit with these civil, area. But is there anything else that specifically you think are going to be the next stories that, we should be paying close attention to and looking into doing?
I think, and I'm going to sort of play off what Sarah said a minute ago, I think it would be really useful, maybe not sexy, right, but to actually take a look at what's happening on the ground at Muscogee Creek Nation on the sort of adaptation front. This new jurisdiction, so what are we doing? What's happening in Indian country in all of eastern Oklahoma, because we've now got state court decisions re-recognizing all 5 of the 5 nations reservations. So how is this working mechanically? We had Parade of Horribles, and that made for great press. But let's look at the reality on the ground and actually see, here, an illustration, Indian child welfare, where a deal was cut between the nation and the state, and that's all sort of working out just seamlessly and fine. Talk to those folks. And how did the negotiations happen, and how has it been resolved? How is the jurisdiction share going to shake out? Criminal side with cross-deputization agreements, a lot of people don't know that those exist, right? How does shared law enforcement work? Because again, everybody's got the same goal here. Nobody's pro-lawlessness in this. And what's the story with oil and gas regulation? I mean, we're far enough away from the decision that things have been happening. And some coverage on that, as you know, as dry as it might be, but you guys are great writers. You can make it interesting for people. But again, just to sort of explain how the real world works when you get outside of the hysteria of a Supreme Court case.
I just want to kind of ask if either of you, this is probably going to be a yes or no question, but do either of you think that we've ever completed comprehensive coverage on a tribal issue or a topic in the post-McGirt era if we haven't sat down with or gotten on record something from the tribes or tribal citizens or Indian law experts?
That's a
well, as an Indian law professor, I tend to, we tend to write these really, really long, boring law review articles with the page half filled with footnotes. And so I really am, in debt to journalists who manage to talk about very, very complicated things without, a lot of jargon and a lot of footnotes and things like that. So that's just a skill set I haven't cultivated in myself. So I can only imagine how difficult it is to get this story right in a short article or in a 1 minute, soundbite. So my hats go off to everyone who's struggled to do this. But yeah, I think making sure that you tell the good stories, right? Because things can go bad in any judicial system, and it doesn't necessarily have anything to do with McGirt. We see crises in other states where, you have a county judge who, was selling children to a juvenile justice facility. No justice system is perfect. But, there's a lot of positive changes happening right now in and around Muscogee in terms of a renaissance of our people. And I just don't see that covered very often. Now, I'm in Kansas, so I don't get the local news, but sometimes somebody will send me something on Facebook, or I'll read the Tulsa World or another local paper, and I don't see as much about the benefits of McGirt that I do about the potential drawbacks or the parade of horribles.
Mr. Robertson, you got anything on that?
I agree. And I do read the local papers. And there really hasn't, at least, I read the big three, I guess, the state, Tulsa.
But there have been a couple of really local, very small town newspapers that have done a pretty good job. So it's not that it's not happening, it's just not getting the splash that the drama gets.
Exactly, I agree.
I think we see like a trend of that. You'll see like the really niche kind of organizations who work hand in hand with, their neighbors are tribal citizens. I know I definitely live in a community where half of my block might be Muscogee Creek citizens too, and some of them are not. And so there's definitely a layer of accountability to the people that you live with when you're reporting that closely to the topics. And it does kind of filter off and become more of a feathered edge kind of thing as you rise up into a larger organization or report more broadly on the topics. But I always kind of remember that slogan that we used to have, like nothing about us without us. And that's kind of always been drilled into my head. So with that, I'm just going to kind of see if you guys have any closing remarks. And I think we're going to wrap it up today. Anything to leave the class with, Sarah?
I can't think of anything very short to say, but thank you for doing this, I guess. And I would just ask that again, when coverage of issues involving victims of crime who have been brutalized by someone else, that we think very clearly about the impact that journalism has on their lives. And with that, I will say thank you again for letting me be part of this. It was very useful.
And Professor Robertson, what about you?
I agree. No, I think this is great. I applaud the organization for doing this and for everything else that you guys do. I mean, you're sort of, you've established yourself as the authorities on Native journalism, and I only wish you all the best at we're expanding nationally and educating more and more people into complexities of these issues.
Thanks a lot. I'm going to pitch it to you, Sterling, for closeout then.
Well, Mado to all three of you, this was just excellent yet again. On behalf of OK SPJ and our partners at Muscogee Media, Mado for joining us, and my special gratitude again today to our panelists for sharing their expertise. The recording of both webinars will be available at oksbj.com and should be immediately available on the Muscogee Media YouTube page through our live stream there today. Mado.
Thanks, Sterling.
Thank you.
Thanks, Angel.